straight ahead on Law and Crime Daily. A death penalty attorney appointed to Lori Vallow Daybell. Is this a sign the so-called Doomsday mom could face the highest penalty in the murders of her 2 children? And a husband charged with killing his wife.
We'll do whatever it takes to bring you back.
The evidence the prosecutors say they have against Barry Morphew. Plus, jury selection begins in R. Kelly's trial. Defense attorneys now requesting charges be dismissed, including allegations the singer gave herpes to a teenage girl, and a grieving widow.
Her daddy is a hero.
A sheriff's deputy killed on duty. The jury now must decide if his the man accused of killing his wife. Law and Crime's Anjanette Levy is here with details on the case.
Brian, Suzanne Morphew went missing on Mother's Day in 2020. Her body has never been found. Prosecutors are laying out why they believe her husband Barry killed her.
Oh, Suzanne, if anyone is out there that can hear this, that has you, please, we'll do whatever it takes to bring you back.
That was Barry Morphew last year, pleading for the safe return of his wife, Suzanne. Her bike was found on a trail where she rode, and her helmet found less than a mile away without any damage. On the first day of the preliminary hearing, a detective testified Suzanne Morphew bought a spy pen because she thought Barry was having an affair. The detective said Suzanne was having a 2-year-long affair with a man named Jeff. In May of this year, prosecutors in Chaffee County, Colorado, charged Morphew with murder after deliberation, tampering with physical evidence, and attempting to influence a public servant. Suzanne's body has never been found. Forensic death investigator Joseph Scott Morgan has followed the case.
There's no corpus delicti, if you will. There's nothing forensically in that sense to hang your hat on, what we would be looking for. Remember, he's charged with first-degree homicide here. So they must have some pretty substantial evidence to still be holding on to him, that they would charge him with essentially the highest count that you can in this category.
Sheriff's deputies, FBI agents, and others have searched for Suzanne, and one investigator testified during the hearing, searching around her home is still a work in progress. A reporter in the courtroom says Morphew's daughters attended the hearing, sitting behind him to support him, despite prosecutors calling him a murderer.
We love you, we miss you, your girls need you.
Now, there was no evidence, according to the detectives, that Barry Morphew was actually having an affair. There was also testimony that the DVR from the home was missing, so there was no surveillance video from the day that Suzanne Morphew went missing or the day prior. This hearing is a preliminary hearing, so it's expected to last about 4 days. At the end, the judge will determine whether or not there is enough evidence to take the case to trial. Brian?
Thanks, Anjanette. Joining us today is criminal defense attorney Julie Rendelman and Terry Austin. Julie, Suzanne was having an affair, according to some of the information, with a man named Jeff. So can we expect the defense to point to him as an alternative suspect?
Sure. I mean, keep in mind that now we have a case where there is no body recovered. So I think the first thing that the defense is going to do is say, no body, no proof that she is in fact dead. The second thing is, well, if they believe that there's enough evidence to establish that she's dead, well, who killed her? Did she take her own life? Or is it the person that she was having an affair with all these years that's a potential suspect? Again, we don't know much because some of it is still sealed, but I think it'll be very interesting to see what, if any, evidence comes out that establishes without question that the husband is the person that committed this crime versus anybody else.
Now, Terry, as we begin through this case, what facts is the prosecution bringing out that make you think this case will be put on for trial?
Well, Brian, so they are holding the facts close to the vest, but we do know that there were 135 search warrants that were issued, and they spoke to over 400 people. That's a lot of interviews and 3 terabytes of information. So there's a lot of information out there. And I think we know that this is first-degree murder. And first-degree murder in Colorado is defined as deliberate and premeditated. So we're going to have evidence of some premeditation here. And I think it'll be a lot of forensic evidence, maybe some computer searches. So we'll see what happens here.
Absolutely. Now, Anjanette, was there testimony about Barry Morphew's truck during the hearing?
Yes, Brian, there was. One of the detectives testified about a tracking device of sorts that was on Barry Morphew's truck. And they said that basically That tracking information showed that from 2:47 on Saturday, May 9th, until 5:37 a.m. the next morning on Mother's Day, that he took steps to get rid of evidence to cover up the death and disappearance of Suzanne Morphew. And they talked about how he basically said he left around for work at a certain time, but it didn't jibe with what that report was showing.
All right, so I guess that's how they're trying to prove this case in the preliminary here. We'll make sure to give you updates as it continues. Thank you, everyone. Now to our other top story. So-called Doomsday mom Lori Vallow Daybell has been appointed a death penalty certified attorney. Lori Vallow Daybell, along with her husband Chad Daybell, are charged with the murders of Lori's two children, JJ Vallow and Tylee Ryan. Last week, prosecutors announced their intent to seek the death penalty against Chad if convicted. Lori's case is on pause for now, while she's deemed incompetent to stand trial. But court records show attorney Jim Archibald is now appointed to her case, alongside attorney Mark Means. According to East Idaho News, Archibald is one of the few qualified death penalty certified attorneys in eastern Idaho. Terry, now that the prosecution is seeking the death penalty against Chad Daybell, is this new attorney a smart way for Lori to cover herself?
It's not only a smart way, I think it's going to be something she's going to need, and I think Mark Means is going to need it. We know that Jim Archibald is a very seasoned attorney as far as the death penalty is concerned. Mark Means is a personal injury lawyer, and he's a family lawyer. He doesn't really have the expertise needed for this type of case, if in fact Lori is charged with the death penalty. So we'll see what happens, but I do think it's going to help her overall at the end of the day.
Now, Julie, the last high-profile case, and he's had a few, that Jim Archibald handled was Brian Dripps, and he got him 20 years to life. Could this be a positive appointment for Lori then?
So it depends on how you look at it. There's an argument to be made that his client was found guilty, and therefore it's not a great person to bring on because he was not able to convince a jury that his client was not guilty of a crime. On the other hand, remember the issue and that we seem to think is that he's being brought on because this is a potential death penalty case, and the fact that he was able to avoid the death penalty in this other case does speak volumes about his ability to be able to convince a jury if in fact she is found guilty and if, in fact, they are seeking the death penalty with regards to this specific defendant.
Yeah, and that Brian Dripps case was heinous in of itself, so perhaps this case being equally as heinous, maybe a little bit more, may help the Lori Vallow Daybell in convincing a jury that death penalty should not be on the table, but I think that is a tall order. But of course, we'll keep an update on the Idaho v. Lori Vallow Daybell case, as well as her husband, Chad Daybell. Thank you both. Still ahead on Law and Crime Daily, what a sheriff is saying about the investigation into New York's Governor Andrew Cuomo. But first, jury selection in R. Kelly's trial. His defense has motioned to dismiss charges before testimony begins. Welcome back. Jury selection is now underway for R. Kelly's trial in New York. But the disgraced singer's attorneys are asking a judge again to dismiss charges against him. And attorneys filed a motion to dismiss charges in his criminal indictment. Defense attorneys say that transmitting herpes does not fall under public health law, and those charges against him are a clear mischaracterization and interpretation of the application of the statute. In a recent pretrial motion, prosecutors allege R. Kelly met a 15-year-old girl in Florida, filmed himself having sex with her, and produced child pornography. Prosecutors say, quote, as a result of the defendant's actions, Jane Doe number 5 contracted an incurable sexually transmitted disease at the age of 17. R. Kelly's accused of abusing women and girls over 2 decades. 12 jurors and 6 alternates will be selected. The trial is expected to last 6 weeks. Back with us is criminal defense attorney Julie Rendelman and Terry Austin. Terry, with 20 or so Jane Does, 2 John Does, and a long list of sexual and racketeering charges, what kind of jury do you think the prosecution is looking for in this case?
You know, I think the prosecution is going to have to look for a jury who hasn't been the subject of any sort of criminal activity, particularly as relates to sexual assault. And that might not be easy because there might be family members, there might be friends who are subject to that. So they're going to have to go through a lot of jurors as far as that's concerned. They're also going to want jurors who won't be enamored with a Grammy award-winning artist like R. Kelly. So it has to be someone who maybe doesn't know his music as much or won't be impressed. And finally, I think they're going to need jurors who can understand the nuances behind the racketeering charge, because that's an important charge as well.
Now, Julie, how do you think the court will handle the motion to dismiss charges involving transmitting herpes to teenagers?
So the law isn't completely clear in terms of whether or not herpes is in fact an STD. I think the bigger issue, Brian, is I think this is the least of R. Kelly's concerns. I mean, these are misdemeanor charges. And even if those cases were dismissed in some way, the judge will likely let in the evidence anyway, because it establishes a sexual relationship with the young woman. And so at the end, I don't think it matters. And if he's convicted, the misdemeanors are going to be absolutely irrelevant anyway. So again, I don't know what the judge's final decision is. I think he is going to keep those charges in place, but I don't think it makes any difference.
Yeah, either stylistically, if you want to call it that way, the jury's going to hear about it and not be too happy about sexually transmitted diseases or infections, or just factually it'll come in as a charge. So it's kind of you're damned if you do, damned if you don't. We'll see how that plays out. Thank you both. Turning now to more top legal news, the trial of Robert Durst has resumed after it was abruptly halted due to a member of the public in the courthouse testing positive for COVID-19. The real estate heir is accused of murdering his best friend, Susan Berman, in December 2000. Prosecutors have rested their case, and the defense's first witness is on the stand. Memory expert Dr. Elizabeth Loftus faces day 3 of cross-examination. Once her testimony concludes, Durst is expected to take the stand in his own defense. Be sure to tune in to Law&Crime Network for gavel-to-gavel coverage. Coming up on Law&Crime Daily, will a jury recommend life in prison or the death penalty for a convicted cop killer? Plus, what criminal charges are being considered against New York's Governor Andrew Cuomo? We're back. Calls are growing for New York's Governor Andrew Cuomo to resign, and the local sheriff is now saying Cuomo could possibly face misdemeanor charges. The woman known as Executive Assistant Number 1 is speaking out after filing the first criminal complaint against Cuomo. She told CBS News the governor groped her twice, first one New Year's Eve 2019.
Seeing his hand, which is a large hand, thinking to myself, oh my God, this is happening.
Cuomo is denying allegations, and his attorneys say she's not telling the truth.
The governor has repeatedly denied that ever took place. And quite frankly, when she first raised this in early March, he was stunned.
But over the weekend, the Albany County Sheriff said a criminal investigation is underway.
Based on, again, I'm really on the peripherals of this, but it would probably be a misdemeanor, possibly a couple.
Here to break down the allegations against New York Governor Cuomo is criminal defense attorney Julie Rendelman and co-host Terry Austin. Terry, Executive Assistant 1, or Brittany Comiso, has come out to say that the governor is a liar and spelled out why. Your reactions to her breaking her silence?
You know, we have seen in the past that there are a multitude of witnesses that don't come out and don't say anything for a while when they are victims to these types of assaults. And here I think one of the issues might have been fear of retaliation. And so when she came out, she decided to do this once she saw Cuomo in a press conference. She actually said that she was offended, that he looked quite arrogant while he was doing this, and that she thought he was speaking directly to her. So I think she hesitated at first because she feared this retaliation in the workplace, but then ultimately she got her courage after she saw him denying basically everything that people have been saying about him, including her.
Absolutely. Now, Julie, the allegations sound like misdemeanor forcible touching or sexual abuse in the 3rd degree. As a former prosecutor, how does a DA's office handle such a serious case with relatively low jail time?
Well, keep in mind, you know, a report was rendered, and the DA's office isn't going to just rely on that report if they're doing their due diligence, which they need to. They should be doing it in every case, but particularly a case where the stakes are so high. And so I think what they're going to be doing is they're going to be crossing their T's, dotting their I's, making sure that there's nothing about the complainant that would render questions about her credibility, because the last thing they want to do is go forward with these allegations, go forward with an arrest, and find out there's something either in the complainant's history or some motive that would have been ulterior to just simply wanting to come forward against Cuomo. And so I think they have a big job to do. They have limited time, obviously, because of the statute of limitations, but I wouldn't be surprised if charges come this way.
Yeah. Julie, you have any kind of inclination as to when we should expect charges? Weeks, months? What do you think?
I don't know, but I will tell you that, it's not just the DA's office that's handling this specific case. They need to speak to every DA's office with every complainant because they want to understand fully the evidence against him in each state, because that enables them to make the best decisions in regards to the case they have before them.
Absolutely, it makes sense. We'll see how that investigation goes because, like you said, the statute of limitations is there. I think it's 2 years on an A misdemeanor in New York. Thank you both. When we come back, will Stephen Wiggins get the death penalty? The latest in the sentencing phase of a cop killer and what awaits him. Welcome back. A Tennessee jury must now decide if a man convicted of murdering a deputy sergeant deserves the death penalty. After a little more than an hour of deliberations, the jury found Stephen Wiggins guilty of all counts, including first-degree murder, vehicular arson, and abuse of a corpse. Wiggins shot Sergeant Daniel Baker in the head in May 2018 and lit Baker's body on fire in his own patrol vehicle. Baker's widow gave a heart-wrenching victim impact statement calling for Wiggins to face the highest penalty.
He worked hard every day to be the best husband, father, leader, and human that he possibly could. He helped many strangers and never expected anything in return. He tried to promote good and always lead by example. I have begged many times for God to let me trade places with him, not because I wish to die, but because Daniel deserves to live. Meredith, our baby girl, our precious little girl that has been forced to grow up without her daddy. She knows that he lives in heaven, but doesn't quite understand that he is never coming back, that he will never be here to hold her, to kiss her, to watch her grow, to offer fatherly advice, to walk her down the aisle, to meet his grandchildren, to do any of the things that a father would, could, and or should be here to do. All that remains are the pictures, a few videos, and many stories of the great man that I know undoubtedly would have given her the world.
The defense says their client deserves mercy, bringing up an instance when Wiggins saved the life of a coworker.
Or the fact that Stephen has helped others in his life. How you will hear in this case that he actually saved the life of a coworker. That may be relevant to you, but it might not be relevant to another juror. And you could give that the weight of life. But you have to remember, this isn't a counting exercise. This isn't you just count up all of these mitigating circumstances. There's no magic number you have to reach. A single mitigating factor, a single piece of mitigating evidence could be the reason that you, in your individual moral judgment, decides to give that circumstance the weight of life. You have to decide whether that mitigating evidence is going to be sufficient or appropriate to grant mercy.
Julie, I hear what the defense is doing, and I understand you don't need a magic number, just a single issue. Do you think that this jury that found Wiggins guilty so quickly, though, will also sentence him to death?
So the one difference is that the defense didn't really put on a defense in the trial part of this case. They're putting on a defense now. They've saved all their arguments for the mitigation phase. And so they hope that it's going to take the jury much longer than an hour to make a decision of such an incredibly important thing. And, look, it only takes one. I think the jury, politics aside about feelings about the death penalty, is going to be hard pressed to find the mitigation that the defense is looking for, considering the heinous nature of this crime and the fact that he had committed other violent crimes in the past. Obviously, time will tell, but I think it's going to take the jury a little longer than an hour this time.
Absolutely. On one hand, you have the heinousness of this crime, who was committed to and how it was done. On the other, it's one thing to say that you support the death penalty, but to be the actual person to vote on it is hard for a lot of people. So, of course, we got to keep our eye on this one. Terry, oftentimes during sentencing, we think the judge has already made up their mind. Here, the jury is deciding. So do you think the evidence so far is swaying them?
It's very difficult to make this decision. And for a jury to come, there have to be 12 of them to make this decision. So it's a very personal decision. I agree with Julie. I think it's going to be hard. This was a heinous, heinous crime. But the medical evidence so far that we've seen in this penalty phase has not been very strong. So I do think we might see the death penalty. Having said that, defense counsel did a great job when he was arguing in his statement. And I think the jury listened to what he had to say.
Absolutely. The defense attorney didn't have much, but he seems to use it as best as possible. Thank you both for joining me. And thank you for joining us here at Law and Crime Daily. We'll see you next time as we discuss justice in America.